Chief Justice, thank you so much for agreeing to speak to us. You were appointed in 2011 when, for all intents and purposes, the court system still fell under the Department of Justice. Why has it been so important for the judiciary and the Office of the Chief Justice to be independent from government?
Well, Section 165 of the Constitution provides for an independent court system. The system that is designed to ensure that judges and the courts within which they operate enjoy dignity, and they are provided with all the support they require to be efficient and effective, so that they can do their work without any fear, favor, or prejudice. Now, it's very difficult for any measure of independence to be enjoyed by a court system that depends largely from either the executive or the legislative arm of government, or both of them combined. It has therefore been necessary from the time our new constitutional dispensation set in for everything possible to be done to ensure that judges enjoy independence in the execution of their core function, which is the writing of judgments, but also that there are institutional arrangements in place to ensure that such administrative functions that are intimate to court operations are handled by the judges themselves.
The issue of budget, we know that this year will be the first time that the Office of the Chief Justice and therefore the court system controls its own budget. Many South Africans might not understand, what's the difference between government or the Department of Justice being responsible and the Office of the Chief Justice being responsible. What is the core difference in those two bodies being responsible ultimately for the budgets for courts?
If you look at any institution whatsoever, whether it is a ministry within the executive, parliament, or any legislature in a province, the Chapter 9 institutions, but even institutions like the National Prosecuting Authority, the Hawks, the IPIT, even the SARS, they all control their budgets. The Auditor General controls his or her budget. The strange thing that has marred the independence of the judiciary in South Africa has been that it did not have a budget of its own. And the negative side of it would be that because the executive through the Ministry of Justice was in control of the budget and even the operations intimate to the court system, when it is thought that it's necessary for security to be scaled down, you come to work the next day, instead of 10, 12 security personnel, you have 4, like the Constitutional Court has now. And there hasn't been any prior consultation. There was an embarrassing situation at some stage of the library budget being cut down without any prior consultation, and understandably so, because they were in absolute control of the budget that ought to be controlled by the judges or the courts. Now, this is the beauty of that measure of independence in relation to court administration. As you know, with the advent of amending the Constitution, with effect from the 13th of August 2013, the responsibility to ensure that case management flows smoothly, the responsibility to establish and monitor norms and standards that would facilitate the proper functioning of the courts rests on the shoulders of the Chief Justice together with the leadership of the judiciary. And for that to become a reality, you need to have a budget. You don't need a situation where, in order to set up a mechanism through which you can monitor court performance, you still have to go to the executive and say, please, we need to do this. Do you think you can make money available to us? One of the key innovations that would really facilitate a better performance by our court system is court modernization. You would be aware that over the years there has been complaints about dockets disappearing, with the result that it takes a long time before, a a new set of documents are procured to facilitate the commencement or the resumption of the trial, and appeals not being proceeded with because the record of proceedings has disappeared. Part of the modernization project that we envision would ensure that there is not only electronic filing of the documentation that come through, very much in the same way as it happens with SARS, but also that we have on-site and off-site electronic record keeping. That would facilitate a very cheap procurement of record of proceedings, because that all that the litigant has to do, unlike now when it's very expensive to secure a record of proceedings, is to connect to the court system and pull out the record of the proceedings that he or she is interested in at minimal cost, if any cost at all. And the possibility of records disappearing as easily as they have been disappearing over the years would come to an end, because you will then have one or two people only who have access to the records, and should anything happen to the record system that you have on site, we will still have a backup system far removed from the court premises. So that way there would be an expeditious processing of trials, an expeditious disposal of applications, and an expeditious prosecution of appeals. So those are some of the things that are very key. Just going back to electronic electronic filing, I beg your pardon. The system as it obtains now is that if you are in Cape Town and you have a case in Johannesburg or Pretoria, over and above the attorney that you have there, you must get another attorney within, I think, 8 or 10 kilometers of the seat of the court, who would then have to file the papers for you. We are saying litigation is very expensive. If we introduce successfully electronic filing, it doesn't matter whether you are in London or New York. You can travel with all the documentation that applies to a particular case as an attorney, as an advocate, and at the touch of the button, you can file your papers, even if it is at 5 minutes before 12 on the day on which you should file. Otherwise, you would have fallen outside the time frames. So there is a lot of work that needs to be done. We need to develop the capacity to monitor court performance, and this is where it comes in. You would be aware that by now, some of the judges are already appearing before the Judicial Conduct Tribunal. And a large number of those judges have to appear before this tribunal, an embarrassing development for all of us, I must say, because they have not been able to hand down reserved judgments on time. Now, with the benefit of proper and regular monitoring of the performance of each and every judge, we would all have been, particularly the Chief Justice and the Judge President, have been able to pick up the problem much earlier and introduce such remedial action or such remedial measures as would have obviated this embarrassing development. And that is where the norms and standards come in, and many people don't understand. Some colleagues even still don't understand the rationale behind the introduction of the norms and standards. They exist to make sure that before, for instance, the 6-month period after which you must be reported to the Judicial Service Commission if you haven't delivered your reserve judgment. Before you get there, within 3 months at most, we would have picked up the delay in the finalization of the reserve judgment. The Judge President, at times if necessary, with my assistance, would then look into the problems that has necessitated this delay. And to the extent that it's a limited experience or just being slow naturally, interventions could then happen that would address the problem that a colleague is experiencing. So in a nutshell, the budget ought to allow us to do much more than we have been able to do over the years. The budget ought to enable us to take judicial education a step further. We have had to cancel some of our educational programs, for instance. The leadership of the judiciary was supposed to get training from an institution based in Canada a capacity building program that would have strengthened the leadership capabilities of all of us. But it required a lot of money, and we had to look at our budget and say, we will not be able to go through this program because our resources are simply too limited. Additionally, we are supposed to have a conference under the auspices of the South African Judicial Education Institute to come up with plans designed to assist both newly appointed judges and acting judges come to grips with the essence of adjudication. We've had to cancel it because the resources were rather too limited to go that far with our training program. But with the benefit of our own budget, and hopefully it will be enough to help us to move as freely as government departments and the Parliament, both the NCOP and the National Assembly, are able to move. We would be able to shift funds around to attend to part of the core business of the judiciary that we haven't been able to touch as a result of not being in control of our budget.
How tough has it been to get to a place now where you have your own budget?
Extremely tough. It's been extremely tough, and understandably so, because it hardly ever happens that change that touches on things of importance becomes a smooth sail. In the first place, it does shock the systems of all who have to let go of some of the responsibilities or things that they have been controlling for some time. But also, it's very difficult to get everybody to understand how the change that must happen is going to benefit not only the court system but the entire country. So it has been very difficult, and it continues to be very difficult.
When you make that presentation, I understand it's the Secretary General that deals with the issue of budget. Is that correct?
That is correct.
In your mind and in the mind of your office, what in the immense kind of landscape of what you're trying to achieve, which you've just articulated, what is the biggest priority or priorities that you feel you need to focus on in terms of your budget?
Strengthening the case flow management project. What we are busy with at the moment, having realized that it takes rather too long for cases to be processed from the filing stage all the way through to the delivery of judgment, we've looked around the world and compared notes with jurisdictions that are doing very well. Jurisdictions like Norway, the United States of America, the UK to a certain extent, and Malaysia. And to a certain extent also Russia, the Russian Federation, they are doing well in terms of court performance. And we have identified things they do which we are not doing. And out of that exercise, through the influence, I must say, largely of the United States of America, we've been able to develop a case flow management model that would best help us to address the challenges that have been confronting the South African court system for a long time. We've been running pilot projects. Happily, the Department of Justice has been assisting with some money there. It could have been better, but we're grateful for the assistance that they have offered. Now, we are at a very critical stage where we need as many of the experts of world acclaim as possible to come and help us refine the product that we have settled for so that we can implement it well, and so that they can also help us to pick up the problem areas as and when they arise. So we are at the stage now this year where we're going to be rolling out this pilot project that has been running in about 6 high courts to all the courts, and thereafter we've got to roll it out to all the magistrates' courts, which, as you know, constitute the largest component of the South African judiciary. So we need money there. We need to develop the capacity to harvest statistics from all the courts. Let me give you an example. If you go to these jurisdictions that I have mentioned, you'll realize that there is no possibility, and I'm not suggesting that what I'm going to say necessarily applies to South African judges, but it could. There is no possibility of any judicial officer loafing around when others are working hard, because we'll narrow down performance monitoring and evaluation to an individual judge. There is a system in place, for instance, in terms of which from your cell phone as the head of court, from your cell phone as the Chief Justice, you can tell when a court in a far removed area is sitting or not sitting. And in circumstances where every arrangement ought to have been made to ensure that from commencement to finality there is no interruption, you would then be able to intervene as the head of the particular court and say, but why have you adjourned? I can't even see on the electronic system the reason for the adjournment. And if it was as a result, it was unjustifiable, you could then intervene timeously before you come across a newspaper report complaining about the problems there. So we need to be able to strengthen our capacity to monitor and evaluate performance, to harvest court performance-related statistics, and to be able to intervene properly in the event of a problem arising in any of the courts. Another priority that I've alluded to is modernization. But over and above electronic filing, electronic record keeping, we need to move towards not only audio-visual remands, but the capacity to take evidence from people who are abroad, from people who are in far removed areas through an electronic system. And a number of jurisdictions that are doing well have gone that far. You see, part of the problem with our system has been that people have to move all the way from wherever they are to come and testify in our courts. They might be sick and not be able to come over, and the consequence of that is that it's going to take far too long before the person is strong enough to come over. But even if they come over, they must budget quite a number of days for traveling and for giving evidence. But with the benefit of this system, which we have seen working very well for other jurisdictions, for postponements, you don't even have to go to that court as a legal representative, and as a witness you can actually give your testimony, whether it is in Russia, whether it's in America, through that system. And that will facilitate the expeditious finalization of cases without compromising the quality of the proceedings, without compromising the quality of justice. One of the major projects that we must embark on, and it's really going to save a lot of money, relates to library services. With the benefit of our own budget, and bearing in mind that it is the judges themselves who labor for hours on end to produce judgments, we're going to tamper with the system in terms of which Jutta and Butterworths are really benefiting enormously from what ought to be our copyright. Let me just explain how ridiculous the system is. We work very hard to produce judgments. Then we send them to the publishing companies. All they do is package them and sell them back to us at no discount. It has never made sense to me. It will never make sense to me. I visited Ghana, for instance, and I was amazed by what they have accomplished, and also Qatar. What they have done is, at a minimal cost, they compile their own judgments. They are in their systems, and even some of the statutes that we are in the habit of purchasing. And by the way, the Constitutional Court is the custodian of all the acts of parliament that are produced. They are here. So what they have done is they have kept them in their website. They are accessible to anybody who wants them at no cost. I think we must move in that direction, and considering how much we pay for library services, a lot of money could be saved. So those are just some of the priorities, and as I have indicated also, embarking on a more aggressive educational system. Our judicial education system had been confined to substantive and procedural law as well as constitutional litigation. But it's important to add to that what they call soft skills. We've learned that from Germany. Communication. It's important how a judicial officer communicates with the witnesses in courts, communicates with counsel. Gone are the days when you had, an unbridled license just to be harassing everybody as you please, because some of the cases are lost precisely because the confidence of people appearing before you has been tampered with. Some orientation on matters that affects the economy, because we come up with a lot of judgments that have a profound impact on the economy without not even as much as some crash course on economic matters. And even politics. Much of what we do impacts on politics, and some orientation on how politics work without seeking to indoctrinate the judges could be of great benefit to the judiciary. So we would want to go that far as well.
You've also spoken about the fact that I read in one of the speeches that you gave that this kind of poor performance of judges has kind of permeated some levels of the judiciary, and your concern about that. Now, you're speaking about monitoring judges and taking preemptive action before it gets to the stage of, for instance, the Judicial Services Commission. So what kind of monitoring would be involved there, and what are your primary concerns in terms of poor performance by judges?
Well, I think the starting point would be, you would recall that we often have to rely on acting judges. And some of them have never been exposed to an adjudicative environment before. They've never said as judges, they've never said as magistrates. And from the time of appointing them up to the time when they start with their work, there is no room for orientation. So you're throwing them into the deep end. And with the benefit of a monitoring system of the nature I've alluded to, you'll be able to pick up their problem areas much sooner than is the case now, so that you can intervene. 2, some of the judges who were appointed on a permanent basis are, we must admit, appointed on the basis of the great potential they have displayed. Now, it's important to have a way of knowing just how well they are doing. I must say, judges, presidents are doing that, but it would be much better if we have a system in place that does not depend on an occasional interaction with a particular judge or a complaint from the practitioner saying, we were appearing before this judge and these are our areas of concern. What they do in the jurisdictions that I have mentioned is that they have an official, even if it's a stenographer, capturing each and everything of significance that is happening in the court. For instance, what time do you start? If you postpone, what are the reasons? And also, when you reserve judgments, when is it reserved? And you keep on checking the progress made in that case until judgment is delivered. So those are some of the things that you will be looking into, because judicial case management that we are introducing is essentially about the following. Very much as is the case with the Constitutional Court. As soon as a case comes through, judges must get involved. They must know what this matter entails. They must facilitate the state of readiness of that case. They must ripen the matter for hearing. And what it entails in these jurisdictions that I've alluded to is this. As soon as it comes through, there is a judge who will be interacting with the legal representatives to find out, among other things, when there has been an exchange of documents that must be exchanged, how many witnesses does each intend to call? Because part of the delays is attributable to the fact that people would be calling 10 witnesses when only one witness would suffice, or when, with the benefit of more meaningful engagement, they could simply agree on the particular piece of evidence and obviate the need to call witnesses. So with a judge who would be hearing the matter involved and who knows exactly what it takes to process a case from the beginning to the end, there would be occasional meetings. They may be telephonic. They may have to come to the judge's chambers to make sure that every step that must be taken to get the matter ready for trial or for hearing is taken. And even when you get to the point where the date of hearing is determined, they come with their diaries to avoid an application for a postponement on the basis that something else has arisen. You settle for the day on which all of you are available. Come the date of hearing, because of the preparatory work that would have been done, the matter will be proceeded with to finality, and it will only be under exceptional circumstances that a postponement becomes necessary. All the hurdles, all the issues would have been narrowed down to facilitate the speedy movement of cases. And it becomes even easier if we introduce what we are seeking to introduce, which is court-annexed mediation. Because some of the disputes, some of the cases that are clogging up the system could easily have been addressed through a process of mediation. What we have discovered is that in those jurisdictions like America that I've alluded to, well over 90% of the cases that previously went through the court system are settled. Are settled because, one, as you go through this process of preparing the case for hearing under the watchful eye of a judge, much of what would have detained the matter and kept it alive in a court system for a long time gets removed, and everybody is forced to appreciate the strength or weakness of his or her case much earlier, and then would realize sooner rather than later that there is no point proceeding to trial. But two, with the benefit of court-annexed mediation, you channel the matter through to mediation, and you would realize that people will soon realize that this is a matter that we can resolve. We don't have to waste our money on legal representatives going through this long trial when in fact there doesn't seem to be much disagreement between us, when in fact there is a win-win situation here.
Some might say that, that looks very promising, but ultimately, we do unfortunately have some judges who have sat on reserve judgments for up to 4 or 5 years, and it doesn't appear like there are any real consequences up until now for those kind of judges. If you have someone who is a so-called repeat offender, who's not giving judgment, who doesn't appear to be responding to the gentle nudges of your office, what do you then do? Is it inevitably destined for the Judicial Services Commission, or is there any other kind of action that could really make such non-performance have direct consequences for that judge?
Well, let me just reiterate that it is precisely because of that problem that judicial case management is being introduced. It is precisely because of that problem that modernization has proved to be an urgent need. It is precisely because of that problem that proper court-annexed mediation that is funded by the state needs to be introduced even at a higher court level. But obviously, when we have done everything within our power to assist a colleague to come to grips with his or her work, but there is no cooperation on his or her part, there is no improvement on his or her part, it leaves us with no choice but to refer the matter to the Judicial Service Commission, the Judicial Conduct Committee of the Judicial Service Commission. And of course, some are saying, but even this Judicial Conduct Tribunal has not worked. It has worked. It's simply going through its teething problems. We've never had an institution like that before, and obviously, people are testing the strengths of the tribunal as they are entitled to do. But from where I sit, it's enough that we came into office at the time when there wasn't a clear mechanism in place to prosecute perceived misconduct of this nature affecting the judges. We moved with great speed and appealed to both the NCOP and the National Assembly to expedite the process that culminated in the production of the necessary regulations that facilitated the establishment of the Judicial Conduct Tribunal. And now we are there. Nobody can accuse us justifiably of covering up for our colleagues. We've taken steps, and I believe going forward, just the very thought of being subjected to this process would cause many to do what they ought to do within the stipulated time frames.
But if one looks at the very unfortunate case involving Judge President John Hlophe, I mean, he's obviously exercised every possible legal remedy at every possible juncture, you know, and he's entitled to do that. But in the eyes of the public, that matter's been dragging on, I think, since 2008 or 2009. It's taken a considerable time, and it's still not resolved. How do you respond to the public who say, but surely you should have sorted this out by now?
Well, in the first place, that started long before I became Chief Justice, I must say. But in the second place, we must remember how that process unfolded. Allegations were leveled against Judge President Hlophe. He also leveled allegations or complaints against the justices of the Constitutional Court. And the matter came before the Judicial Service Commission. Now, the Judicial Service Commission itself took a decision. After some evidence had been heard, they took a decision in relation to what was to happen to the matter. Having taken the decision that the matter was to be ended at that point, some public interest grouping, it may have been the Democratic Alliance, if I'm not mistaken, I don't remember now, took the matter to court. They challenged that decision and even appealed that decision to the Supreme Court of Appeal. So Hlophe did not initiate anything at that stage. These parties, as they are entitled to, in a democracy that we find ourselves in the interest of the public, sought to do something, took it to the SCA, and from there, I think it was Judge President Hlophe who then appealed the decision of the Supreme Court of Appeal to this court. Even now, after setting up the Judicial Conduct Tribunal, which I did, the matter was before that tribunal. Judge President Hlophe did not challenge the composition or the jurisdiction of the tribunal. It is some other colleagues of ours who did that. So I have to raise this because quite often it's almost as if Judge President Hlophe is the one who doesn't want to cooperate, when in fact the fact of the matter is different role players, as and when they see the need, choose to exercise their constitutional rights to mount whatever challenge they deem appropriate. Now, what do you do as Chief Justice when constitutional processes are unfolding? Do you then, because some people would prefer this or the other way, act as if the people like Judge President Hlophe, Judges Nkabinde and Jafta, and the DA do not have rights to exercise and seek to interfere in circumstances where neither the Constitution nor the law allows you to do? I think we must just allow this process to unfold, assured that at some stage it will come to an end.
You know, I think one of the more difficult areas which falls within the terrain of your office is obviously the interpersonal issues between judges and managing that. I mean, and I don't know if you want to comment on that, but there's been reports of unhappiness over Judge Hlophe marrying a colleague at his court, and reported unhappiness from some of the judges. When in those situations does your office get involved, or do you get involved? How do you manage those kind of interpersonal dynamics within the court environment between judicial officers who themselves are human beings and may have kind of personal issues with each other? How do you resolve that?
Well, maybe I should start it where you have started it. Love is a very powerful force. And I don't think any of us should seek to interfere with true love. But zooming in on the Judge Tlhophe situation, I think Judge Tlhophe and his fiancée are wise enough to know that their marriage has raised eyebrows, and they must have known this long before they even made it known that they were going to get married. Quite apart from that, I just can't imagine any normal judge seeking to keep his or her spouse lazy, doing nothing, denying her the opportunity to develop herself so that she can also be counted among competent and well-respected judges in the division and in the country, by not allocating her work. Because it's going to be obvious to every judge and even to the practitioners that this judge hardly ever appears in court, or this judge gets all the all the high quality cases that come before this court. She's been profiled. She's preferred above other judges. I don't think any judge president would want to corrupt the system like that. I think we've got to give them credit, not only that they are wise people, but that they are principled people. They ought to know the obvious. But in the unlikely event of an undesirable development arising, it will be dealt with, and they know that. If there is one thing I've made clear, it is that we've got to be upright. I can't be seen to have been speaking as strongly as I did to members of parliament and of the executive before they took an oath of office and an affirmation last year, when in fact there is no commitment on my part, when in fact there is no intention to ensure that all judges are committed to their oath of office or affirmation. So I don't think any issue will arise out of that. And I'm not aware that judges have raised a concern. I've seen in some newspaper over the weekend that it is advocates who are expressing opinions on the matter.
Just moving on to the functioning of the criminal justice system in South Africa. We've seen recently a lot of very negative reports, particularly on the operations of the police in terms of investigation, when one thinks of the Oscar Pistorius matter, where there was, manifest, interference with the crime scene. It wasn't properly managed. We see, in the Dewani matter, Section 174 discharge granted to Mr. Dewani because the judge in that matter didn't feel that there was adequate evidence to even compel him to testify. Judges are often put in a very difficult position where they are at the tail end of the investigative process. They're really the people that are presented with the final product of a whole lot of other people's work, and they need to really hold that work up to the light. In light of that, and in fact, in light of the fact that these were both high-profile matters where one would have thought that due diligence would have been applied, are you concerned about the kind of police work, about the kind of investigation that's coming before judges in terms of criminal cases, and the kind of position that puts those judges in?
I'm very concerned not just about the criminal justice system, by the way, but the entire justice system. And it is for this reason that on the 30th of October 2012, I I moved for the establishment of the National Efficiency Enhancement Committee, which was cascaded down to all the provinces during the course of 2013 and part of 2014. That National Efficiency Enhancement Committee brings together the National Commissioner of Police, National Commissioner of Correctional Services, the leadership of the attorneys profession, the leadership of the advocates profession, Legal Aid South Africa, Road Accident Fund, Department of Justice, Public Works, Health, Social Development, all the key role players in the justice system. I don't have to elaborate how each supports the court system. We agreed to come together so that the problems that we know exist within these departments, within these institutions, could be identified, and behind closed doors explore possibilities of addressing them. You're talking about the police. One of the issues raised was, for instance, in jurisdictions where there is peace and stability, one of the critical features that we have noticed and that colleagues in those jurisdictions have told us play an important role is police visibility. That is why when you go to Germany and the Netherlands, you see people cycling even as late as 12 midnight because there is meaningful police visibility. And two, that the safety mechanism when people are recruited is also important, so that you don't find a criminal who would come in and be taking bribes, a person who has been corrupt all along, coming into the system and therefore furthering his or her criminal activities in circumstances where he's being paid to bring an end to those activities. But also the quality of the training that these people are subjected to and ongoing capacity building programs that they received. We said you've got to be careful who offers this training. What are the credentials of these people? What is their track record? And so we've identified problem areas. Another problem, of course, is these arrests. We said to them, one of the reasons why we have backlogs in the court system is because police are often just too quick to arrest. It is not in every case that you must arrest, because the minute you arrest, it means within 48 hours people must appear in court. And the time that magistrates should be using to try cases that have been awaiting trial for a long time must then be taken up by the postponement of these new cases, inquiring whether they've been beaten up or not, and even bail applications that can occupy you for as long as a month. So we say arrest only when it's strictly necessary. Find a way to resist the pressure to arrest in circumstances where you could just continue with your investigations and not arrest as early as you often do. So that's the police, and there is an understanding there. We meet twice in a year to check the progress that is being made in the implementation of the measures that the National Efficiency Enhancement Committee has proposed. The same applies to correctional services. We also meet with them. You say there's a lot of recidivism here, and it has to do with the fact that rehabilitation programs that have been taking place over the years are not all proceeded with. We understand that, we operate under very tight budgets. The economy is not as favorable as we would want it to be. But something has got to be done to make sure that, some of these programs are reintroduced. The educational programs, for instance, in some of the correctional facilities have ceased to exist. I say it with authority because the constitutional judges every year visit at least one judge, visit at least two correctional facilities to interact with the inmates, to interact with the officials, and just get a sense of what is going on in there. We're saying if you move more aggressively in the area of rehabilitation, in the area of education, one, recidivism would come to an end. Two, when people are integrated into society, they would be radically different from who they were when they went in, because something would have happened. And I must say, I was gratified to see on television the other day some of the people, I think it's in your program, isn't it? Against All Odds, one of your programs, to see what strides some of the former inmates have made as a result of the skills transfer that took place while they were still incarcerated. So we're looking at that. And Correctional Services, of course, has said to us, but you are also to blame as the court system, because we have some 45,000 awaiting trial prisoners for periods ranging from 2 up to 5 years. And we picked that up as we visited correctional facilities. And it all has to do with the inability of the court system, of the judiciary, to do the things that they know must be done to turn the situation around, because we are not in control of things that we ought to be in control of to bring about that change. Legal Aid South Africa, there's been concerns about the capacity of the legal representatives, their unavailability, and under their unavailability, I beg your pardon, and under the leadership of Judge President Dunstan Mlambo, a lot of progress has been made. The list goes on. The organized profession also, the postponements that they often asked for. So we are aware of the problems, but we are addressing them within the capacities available to us. But the Dewani matter, I think you're right to say we are at the end of the chain. A lot has to happen before judges get involved. But something that also must be done, and we raise this with the prosecuting authority, we know there are budgetary constraints, is also capacity building. I was a prosecutor, by the way, and during those days, the head of the court appeared in court. And when the juniors did not have court work to do, they would go and learn from their more experienced seniors. At times, you would even serve as a junior for the SC in your office so that you can learn from him or her how best to do your work. One of the serious mistakes that were made some years back was to say, as soon as you are appointed to a leadership position as a prosecutor, your responsibility is to manage the office and nothing more. So the skills transfer that had been happening over the years ceased to happen, and the result is the junior people had to fend for themselves with very little or no guidance from those who had the wealth of experience to guide them along. So we said to the prosecuting authority as a collective that there is a need to strengthen the capacity of the prosecutors, to expose them to more training, but also it is important to be careful about who offers that training. Some of the prosecutors are exceedingly good, but a lot of work still needs to be done insofar as others are concerned, because we've seen some of them appear here in the Constitutional Court, and it has given us some reason to be concerned. So we are working on this, on these challenges together. We're reviewing progress. I hope the enthusiasm with which we approach the establishment of the National Efficiency Committee and its provincial counterparts would continue, because the sure way of killing a good and a beneficial project is to begin to fizzle out of it as the years go by.
How do you respond to the kind of criticism that was levelled at Judge Thokozile Masipa and Jeanette Traverso over those respective matters, the Oscar Pistorius and Dewani matters?
I think it was vicious. I think judges must be criticized. The public must always feel free. The politicians, whether in the ruling party or the opposition parties, must always feel free to criticize the judiciary when They are concerned about the judgments delivered by the courts, and especially when they are parties and they have lost and it's hurting, we expect them to be critical of us. But I think there is just a line that we shouldn't cross. We shouldn't be personal, because it is not our personal agendas, our personal ambitions that drive us to arrive at whatever outcome we arrive at. We look at the law, and in line with our oath of office, to the best of our ability, we come up with decisions that others will like and others not. I think when you begin to characterize a judge as a moron, that's not unnecessary. The public should please spare judges the insults. I said in the past to Sanef that if you really want to be hot, if you want to criticize beyond measure, heap it up all on me. Spare the judges all the criticism. The same applies to Justice Traverso. I mean, what do you expect her to do? Part of the problem is that when a person loses his or her life under extremely tragic circumstances, or when a person is gang raped, a young person, it evokes our emotions and we expect a particular outcome and nothing else. But if a proper analysis of the facts and the law leads a magistrate or a judge to a conclusion that is different from that which we expected, then we begin to suspect foul play, we begin to suspect that there is something wrong with the judge. The public needs to understand that all we have to do is what the Constitution says we must do as set out in our oath of office. We can do no better than that.
I think it's very difficult because often people, as you say, respond to things on a human level. But judges almost have to rise above, they have to rise above that human level, and they have to interrogate the evidence in quite a cold and dispassionate manner. And I think I'm sure that there are many moments where judges on a human level feel a certain instinct towards an accused, but on a legal and judicial level, they have to treat that in a very, very different way.
Yeah, absolutely, absolutely. One of the major projects that we have sought to embark on as the South African judiciary is just to reinforce our sense of independence, because there are just too many pressures out there. The public and public figures can be very vicious at times when they are unhappy with a decision that has been rendered by a judge. But I think we would do well, even in our outreach programs, our educational programs as the judiciary, to enlighten the South African public about our role. It's a very special role. And I keep on repeating that if we ever get to the point where the judiciary is either controlled by the executive or parliament or the opposition parties or big business or some secret organizations, then we are doomed. Because what it means is that in any case where those who have the capacity to manipulate them is involved, the outcome is predictable. The judiciary is the conscience of the nation. The judiciary is the guardian of our constitutional democracy. And we should at all times act with great humility, but with the necessary firmness. We should never get to the point where we so much want to be promoted that we can do just about anything to secure a promotion. And the South African judiciary so far has done very well. We should never look like, upon an analysis of our judgments, look like whenever certain people, certain institutions have a case before us, Judge so-and-so will always agree with them. It should never be found in the South African judiciary, because any such inclination, is a demonstration of the corrupt mind and heart of that particular judicial officer. And there is no room for that in our system.
We did see a pattern oftentimes in litigation involving government about the separation of powers debate. And oftentimes, whenever there was a challenge to a particular policy decision or enforcement of that policy by government, this rhetoric of the courts shouldn't, come into this particular territory, shouldn't make a decision about this was used. That seems to be changing. But what's your perception? Is government understanding the necessity of court involvement in decisions that are irrational? Are you finding that there's less of that kind of separation of powers argument? Is government taking the courts more seriously now, do you think?
Well, I think the South African government has always taken the courts seriously, because unlike in other jurisdictions where courts would render a judgment or a decision and the executive or parliament would just ignore that judgment, we haven't come across those situations, and it's a plus. And I mean, in the e-tolls judgment and recently in the Helen Suzman Foundation case that this court, the Constitutional Court, has delivered, we said something about the importance of separation of powers. And hopefully that will be taken to its logical conclusion, because you still have, some involvement, significant involvement by the executive in the space that ought to be kept separate for the judiciary, and court administration is one such space. And hopefully the National Development Plan, to the extent that it provides for the executive to expedite a judiciary-led court administration system, I hope that will be done. But I think it is proper that whenever the executive has a sense that we are encroaching on their terrain or their turf, they should speak out. Because the last thing you want to see are some maneuvers, secret maneuvers designed to unsettle the judiciary in circumstances where, nothing was ever said to indicate what the concerns are. But of great importance is, as and when the executive or anybody for that matter has a concern about the judiciary, they shouldn't generalize. They must tell us, in a particular case, this is what happened, and with the benefit of legal advice, we think the court was wrong in this and the other respect. Because generalization can be very general, can be very dangerous, I beg your pardon. We need to know exactly where the area of concern is, so that if we think it is necessary to address the issue, we can do so. But again, I can't emphasize them enough, the dangers of generalizations, because it paints the entire judiciary with a particular brush and creates an impression to the general public that is negative about the judiciary in circumstances where the motivation behind that conclusion or that opinion is not shared with us.
But in that Helen Suzman matter, which many people said was very much about reinforcing to some degree the independence of the Hawks, particularly about the issue of suspension of the head. Shortly after that judgment was made, the minister suspended the head of the Hawks without following arguably the necessary steps, and that ended up in court again. So I mean, what do you make of that?
Well, in the first place, I wrote the judgment of the majority judgment of the Constitutional Court. And in the second place, I don't know whether the minister is going to appeal the decision of Judge Bill Prinsloo in relation to what the correct understanding of that judgment is. And should he decide to appeal, I would like to be part of the panel. So I think I would be well advised not to say anything on that matter.
No, understandable.
Yeah.
Given the kind of resistance that you've experienced in this fight for the judiciary to be independent, is there any apprehension that you have that in seeking an adequate budget for what you need, you may again face resistance?
Absolutely. I think there may be resistance. It's part of the project. This is a massive project. It's a radical paradigm shift from how the judiciary was known to operate from the apartheid days. And we are not naive. We've never thought that it was going to be an easy process. From where we sit, we think there's going to be resistance all the way through, just as there was resistance from the very beginning. But we are confident in the knowledge that eventually South Africa will have a court administration system led by the judiciary, created in terms of legislation. Because you see, the reason why we have submitted a proposal to the executive for the establishment of that kind of a court administration system is because for as long as the Office of the Chief Justice is a national department, the judiciary doesn't quite have as much control as it requires, as it needs to be effective. Because every national department has a political head, and you'll continue to have the Minister of Justice involved in this national department. The Secretary General is, for all intents and purposes, answerable to the Minister. If she doesn't behave, it is the Minister who can institute disciplinary steps against her and other officials in the department. So it was just a stop-gap measure, this kind of administration that we have, en route to a truly independent court administration system of the kind envisaged by the National Development Plan.
There is, my last question, there is perhaps an irony in the situation that, you know, when you were initially appointed, there was a great deal of controversy, and people painted you as somehow some kind of government lackey, that you were the president's choice, that you were going to go along with whatever government wanted. You've now become one of the strongest voices for judicial independence, and you've also given a number of judgments which have held government very firmly to account. Do you believe that you've really showed the public who you are as a judge in light of all the things that you faced when you were first appointed?
Well, I hope so, because during my interview, I made a few undertakings, and one of them was that I was concerned that the South African Judicial Education Institute had been established as at that time for 2.5 years, and yet it had not been able to run a single training program, and that I was going to make sure that it begins to run its training programs as a matter of urgency. We had our first meeting, I remember, on the 10th of November, 2011, the year on which I was appointed. And from the 16th of January, the next year, in the space of within 3 months, we had training programs running for the judges, for the regional court magistrates and the district court magistrates, and it's been running ever since. And soon thereafter, I embarked on the process of ensuring that those judges against whom allegations of misconduct had been leveled, go through the necessary disciplinary processes. I met the Speaker of Parliament, the Chair of the NCOP, their portfolio committees on justice to say, you've got to fast-track this thing. I met the Minister. And also the Office of the Chief Justice. I immediately met the Minister of Justice. Then Mr. Harebe, he was here. I said, look, we have waited for our independence for far too long. It never made sense to us that all the institutions in this country control their own budget, their own administration. They are able to vouch for the competence of people who provide support to them because they would have participated in their appointment. We have never understood why an arm of the state should not have the same possibility. And as you know, the norms and standards are up and running. There were projections that it will never fly. Up and running. We've done a lot of progress. Case management system is in place. And as you said, I've written judgments, and I hope that the public have come to realize that I wasn't lying when I said all I ever want to do is to use this position of privilege to contribute to the well-being of South Africa, to make sure that all South Africans experience the kind of quality justice that the Constitution promises them, delivered to them expeditiously without, as I said, compromising on its quality. So I hope I have done that. It's a very difficult position to occupy, because you can't fire, you can't redeploy anybody, and people know that their independence is constitutionally secured. So it challenges you as Chief Justice to dig deep in your leadership capabilities that have been lying dormant, to bring your colleagues along as you shape South Africa into this vibrant constitutional democracy that it was designed to be.